Welcome to Political Paradigm. I'm Terry Ikumi. Now, the past week has been awash with reactions to the SAMOA agreement and the LGBTQ concerns. The federal government says it waited 7 months to sign that contract and that there is no mention of LGBTQ or anything suggesting such in the agreement. Yet, concerns remain. Well, that's our prime focus on Political Paradigm today. My guest is a lawyer, former lawmaker, and former senior special assistant to President Muhammadu Buhari on National Assembly matters to discuss the SAMOA agreement and concerns about procedures for signing international treaties, protocols, and agreements, and the exclusion of the National Assembly in the entire process. We'll also look at some pieces of legislation currently being considered by the National Assembly that are generating public concerns, such as the death penalty for drug peddlers and the proposed bill to ban open grazing. My guest is Senator Enang. Senator Enang, welcome to Political Paradigm.
Thank you very much, and thank you indeed.
Nice to see you again. You look well rested.
Thank you very much.
Taking a break from politics, I see.
No. I haven't taken a break.
Well, we'll talk about that.
Actively on the field.
We'll talk more about that.
Yes.
Well, let's begin with this SAMOA agreement now. And I'd like us to take it one step at a time, such that clarifications are made on every issue. I'm sure you're very much aware of what's been happening in the public space with regard to the SAMOA agreement. So let me start by asking you, based on clause-by-clause clarification. As a lawyer and former lawmaker, let's look at this controversial clauses, and get clarification. So one of the clauses which is generating concerns is Article 2.5 of the agreement. It says that the parties shall systematically promote a gender perspective and ensure that gender equality is mainstreamed across all policies. What's your understanding of this clause with regard to the concerns around LGBTQ?
Most legislations in the world, not just in Nigeria, seeks to promote gender equity or gender balancing. Not just balancing, but gender participation. And gender does not mean same sex or equal. It means male and female. That's the simplest definition. And most legislations say that wherever you are, whatever you want to do, you must ensure gender balancing, gender participation. I'm sure there is a bill being reintroduced in the National Assembly now to reserve certain seats for the female gender. And under the enhanced protocol signed in 2016 by President Buhari, which compels member states of ECOWAS to to ensure direct election of members to the ECOWAS Parliament and not taking members of the National Assembly of those states, of member states, to the ECOWAS Parliament. It provides that at least 30% of female shall be represented shall be part of the delegation. So this at all does not in any manner suggest lesbianism or gays or transgender or any such thing.
Boy, while seeking clarification, you do understand that the Western world has sort of expanded the gender definition to include the LGBTQ. I need not spell them out entirely. So would it be out of place for anyone to be concerned when gender issues are put into documents like this without spelling out what genders are being referred to?
When you seek interpretation, you'll seek interpretation within the municipal law of the country, within the municipal law of Nigeria. In the municipal law of Nigeria, under the Marriage Act, marriage is defined as a union of man and woman. And in 2013, when there was this wild movement about the LGBT, Nigeria, through the National Assembly, the House of Representatives and the Senate, we passed the Same-Sex Marriage Prohibition Act 2013, which was signed into law by President Jonathan on the 7th of January 2014. And I remember I was in the Senate. David Mark presided on that day. We passed. the Kweremadu, the Atiku Bagudu, Senator Atiku Bagudu, who is the current Minister of Budget and National Planning, was on the floor the day we passed it. He was part of the delegate of the Senate that passed it. And I remember that in passing that act, Senator David Mark, as Senate President, a devout Catholic, stated, and I remember the word he used when we passed the act. He said, if this will make any country willing to deal with Nigeria, to say that because we've passed this, they will not extend financial relationship to Nigeria, keep your money. That is what David Mark, as President of the Senate, presiding on that date, said. I was on the floor. All the senators were on the floor. And I specifically say, again, that Atiku Bagudu, the present Minister of National Planning, who is mentioned to be part of he was on the floor. He was in the Senate with us. And I say that he cannot, having been part of passing that act, go into a thing like this, an agreement of this nature. So, please, it is important that Nigerians should please appreciate that whatever international agreement you sign, the agreement is valid and subsisting subject to the municipal law of that country, subject to the law of Nigeria. First, the Constitution of Nigeria. And this SAMOA agreement, it is a document intended to expand economic and other relationship between African and organizations and other countries. But Nigeria has the 1999 Constitution. And under the 1999 Constitution, a treaty is not enforceable in Nigeria except to the extent to which it has been domesticated in Nigeria.
Well, we will come into that. I just want us to clarify the two controversial clauses.
Yes, please.
Before we go into the details of procedures of signing treaties, protocols, and agreements. So you established already that Article 2.5 of the agreement does not suggest any LGBT concerns. Yeah. How about 29.5, which says that the parties shall support universal access to health and sexual and reproductive health commodities and health care services, including for family planning, information, education, and integration of reproductive health into national strategies and programs. This is the second clause that is in contention. This is
even more clearer and doesn't import anything that leads to LGBT.
So we can say
it does not promote it. It does not compel any party to be part of it. It does not even suggest that is going to be part of a condition of a congregation or a consideration.
So we can say, we can now say that nothing in the document suggests any LGBTQ concerns.
No.
Beautiful.
None.
So, but then, is it okay to have certain grounds of concerns? For one, before this document was signed or reviewed and signed, the initial document contained LGBTQ provisions, which some member states protested against, and then the EU had to modify that. Now, in modifying that, the EU released another document that says that it has certain concerns with the implementation of this agreement, fearing that persons could be discriminated against based on sexual orientation. So bearing that in mind, and we also understand that there's a provision of the SAMOA agreement that says that the EU can bypass the government to fund certain NGOs and civic organizations fund through without going through the government. Yeah. So bearing this in mind, should there be concerns about perhaps any underlying plans, I guess?
I wouldn't think, I say as a lawyer of good standing that there is no such thing. There is no such thing and there is no such concern. And I repeat again, the extent to which you sign an agreement, it is enforceable in your country to the extent to which it is allowed by the law of your country. The Constitution says that the treaty must be domesticated in Nigeria and must be in consonance with the law of Nigeria. And I want to say with respect, if I can have privilege to read the provision, there is the Same-Sex Prohibition Marriage. Same-Sex Marriage Prohibition Act, which I said was signed, was passed in 2013, assented to in 2014. And I could read just very briefly what it says. Be it enacted by the National Assembly of the Federal Republic of Nigeria. 1. A marriage contract or civil union entered into between persons of same sex is prohibited in Nigeria, and B, shall not be recognized as entitled to the benefit of a valid marriage. 2. A marriage contract or civil union entered into between persons of same sex by virtue of a certificate issued by a foreign country is void in Nigeria, and any benefit accruing therefrom by virtue of the certificate shall not be enforced by any court in Nigeria. 2. A marriage contract or civil union entered into between persons of same sex shall not be solemnized in a church, mosque, or any other place of worship in Nigeria. 2. Sub 2. No certificate issued to persons of same sex in a marriage or civil union shall be valid in Nigeria. Only a marriage contracted between a man and a woman shall be recognized as valid in Nigeria. All the other rest are going. All of them go on this way. In fact, let me just take only one other one. The registration of gay clubs, societies, and organizations, their sustenance, processions, and meetings is prohibited. 4 sub 2. The public show of same-sex and amorous relationship, directly or indirectly, is prohibited. 5.1. A person who enters into same-sex marriage contract or civil union commits an offense and is liable on conviction to a term of 14 years imprisonment.
So the law is clear.
The law is clear.
Understandable.
The law is in Nigeria, there in Nigeria. And any agreement or any protocol, convention, or treaty which you enter into outside, okay,
that
for the purpose of Nigeria, for the purpose that contravenes the Constitution or contravenes this law or any other law, is to the extent of that contravention or inconsistency void. So Nigeria, even if it were signed, which is not considered, which is not correct, has even been accepted, Nigeria is not, no officer of the government in Nigeria, no government of President Tinubu or any government in Nigeria
can implement it.
Has even signed it, and so it cannot even be implemented. If you think there is any provision which you want to interpret in the SAMOA agreement as granting right, as granting LGBT right, then it has been annulled by the provisions of this Same-Sex Marriage Prohibition Act.
Senator Enang, just before we go into the procedures for signing or dealing with treaties, agreements, and protocols, I want us to get something clear. Considering the agitations in the public space with regard to these LGBTQ concerns, there are some who believe that with the way the West is defining gender, when documents come to us that suggest gender equality or gender-related issues, should they be defined in our terms to be man and woman? Or should we accept it because we believe that our laws will override whatever treaties we sign?
There is no such definition or ambiguity even in the treaty, even in the protocol that has been signed or so. There is no such ambiguity. And if there is anything which any person wants to think as meaning that it has been cancelled and overridden by the specific laws in Nigeria, the Constitution, and the Same-Sex Marriage Prohibition Act.
Very well. But you already started talking about the procedures for signing treaties and agreements and all that. Now we hear that National Assembly wasn't carried along. As a former lawmaker and as a former senior special assistant to the President of National Assembly, you were the middleman between the President and the National Assembly. Take us through the process of signing treaties or reaching agreements, basically, on behalf of a country, because we do understand that the executive cannot reach certain agreements on behalf of a country without going through Parliament. So take us through the process.
The process is simply that when a treaty comes to Nigeria, and before you sign that treaty, you have to lay it before the National Assembly. And the National Assembly will pass it, either as a treaty or a convention or protocol to a convention. Now, but Nigeria has had one problem since 2001-2003. In the House of Representatives, I was chairman of the ad hoc committee on treaties. It is now a standing committee. And we worked on several of these treaties. We were worked in and they are part of the laws. From 2003-2004, some scholars started saying that the Nigeria can sign treaty without going through the legislature. I said no. Now, in 2009, I chaired the Rules and Business Committee, and I raised this matter again on the floor. And the National Assembly, House of Representatives, they noted all the treaties which has been signed by Nigeria, which has not been laid before the National Assembly. And we moved a motion asking the executive to bring this treaty to the floor. It was not done. In 2013, I was in the Senate. And as chairman of the Rules and Business Committee, I brought up this matter again of treaties before the Senate. In fact, the Senate discussed it and did not reach a conclusion.
Did you hinge your argument on your personal conviction or constitutional provision?
I said it on the constitutional provision.
What provision is that?
The provision on relating to treaties, Section 12 of the Constitution, or thereabout. And in 2012, 2013, the Nigerian Bar Association had a conference in Lagos, in Calabar. And this question arose so much that it became a great national issue, and I was to be on that forum. I had to abandon NBA conference in Calabar, flew down in an emergency to participate in the talk that the treaties must be laid before the National Assembly. It didn't go through, and those treaties are still being signed without being done. As advisor to the President of the National Assembly, I raised this matter to the President, to President Buhari, by memo, and it was referred to the Minister of Justice. The Minister of Justice interpreted just as it was interpreted in the 2013 by the then Attorney General from Kogi State, the then Attorney General by the International Law Department, that there is the treaty-making procedure of 1993, and that they are working on this depending, in accordance with the treaty-making procedure of 1993. I argued with them that the treaty-making procedure of 1993 was under the military, that it is the provision of 1999 that has said that treaties must be laid before the National Assembly, and that you cannot rely on the provision of treaty-making procedure of 1993, to deal on treaties when the Constitution has come into effect. Under the 1993, there was no National Assembly for you to lay the treaty before. And the 1999 Constitution has supplanted and superseded the treaty-making procedure of 1993. Now, that was taken. Mr. President forwarded to the National Assembly, to the Minister of Justice. The Minister of Justice, through the International Law Department of the Federal Minister of Justice, wrote back to advise the President that the 1993 Act, treaty-making procedure, and that it is not necessary to lay all treaties before the National Assembly. That is why you don't find these treaties laid before the National Assembly. I want to urge the Learned Attorney General of the Federation, Fagbemi SAN, that he should take a look at this again and then make sure that these treaties are laid before the National Assembly. Because if these treaties like this, like the SAMOA agreement, were laid before the National Assembly, all these questions that everybody has become a lawyer, that everybody has become a diplomat, that everybody has become an interpreter, would have been a discussion before the legislature, which the legislature would have said yes or no. There is this provision.
I want us to get something clear.
Yes.
To understand the difference or connection between a treaty and an agreement. Are they one and the same? Because the Constitution, Section 12, which you quoted, describes it as a treaty.
No, it is not every agreement that is a treaty.
Absolutely. So is the executive obliged to submit a treaty and an agreement?
If this agreement is pursuant to a treaty, if this agreement, the SAMOA agreement, is pursuant to a treaty to which Nigeria is a state party, then this has to be laid before the National Assembly as protocol to that treaty.
But is it?
I cannot say yes. because I have not seen a treaty on the African, Caribbean, and Pacific trade deal, economic relations deal, on this. But it is for the federal government too. And I'm glad that the Minister of Information and the Minister of National Planning and Budget, when they were explaining to the public, had said that they had passed this through the Federal Minister of Justice and the other institutions of government, and all the interpretations were properly given.
And he also explains that it is an agreement,
it is
not
an
a
agreement.
treaty.
Yes, it is not a agreement.
So
even if it is an agreement pursuant to a treaty, so long as the interest of Nigeria is involved,
it must go through the National Assembly.
It must have to be laid before, even if it is for information. You forward it to the Senate President and the Speaker, and it is laid before the floor. Because agreement or anything, the persons who are to use this to make laws, to define the budget, to plan the economy, is the National Assembly. So they have to know everything, even if they don't have to speak on it. It has to be laid before them or made available to them.
Does this apply to, say, loans, aids, grants, or perhaps, as it was in the case of the former president, Muhammad Buhari, when we received the Abacha loot, and the Minister of Justice at the time, Malami, explained that we were directed, or the agreement signed, said that the money should go to the poor. And National Assembly couldn't understand why the recovered loot, I think from Britain at the time, was being...
I didn't agree with it.
Yeah, exactly. So saying that...
Whatever it is, if you receive money from a refund from Nigeria, it was looted from Nigeria, is it not?
Absolutely.
Now, it was money of Nigeria. It has to go to the legislature. Even if the agreement or the everything, the conditions were that it has to go to the poor, it has to go to the National Assembly to appropriate it for the poor, because it is revenue. No other authority can, unless it goes through the legislature to appropriate. But now, the other issue you're talking about is if it were a loan.
Yes.
Now, if it is a loan, you cannot take loan either as a state government or as part of the federal government without it being approved by the National Assembly. That is not part of a treaty.
Well, then,
so any loan arising from any of these agreements, or any fund, rather, I won't call it loan because none of them has referred to loan to my knowledge.
But you know that at the time, the minister's explanation was that such recoveries are not subject to local legislation in view of multiple sovereignties involved at the time.
I think that was getting too technical, and the Nigerian constitution is superior to any agreement, and nobody can sign any agreement that infringes on the provisions of the Nigerian constitution.
Senator Enang, while you insist that all these loans, aids, agreements, treaties should go through the National Assembly, I want to ask, is there a caveat in case of emergency? Because you recall that under Buhari, we had a case where the president made an agreement to purchase a Tucano aircraft, and he did not inform the National Assembly until it was made public, and he said he did it in anticipation. So when there's a window, when there's a short window, is there room, or is there an exception with regard to how quickly the executive or the president can act without going to the National Assembly?
I was centrally involved in as presidential liaison in the issue you're talking about. It was the explanation, as it were, that it was country to country. It was treasury to treasury. But it did not accept the involvement of the National Assembly. It made provision, later that it has to be gone through the National Assembly. In fact, I remember having gone to Dan, I think he was Minister of Defense then, he was Minister of Defense then. I had a meeting with him in his office over the details which the Mr. President, with the Chief of Staff, was to perfect for Mr. President to forward to the National Assembly for appropriate legislative action. So that was what it was. So it wasn't a case of flagrant disregard of the legislature.
Or was it an error? Was it wrong?
No, it wasn't wrong.
Was it right? What made it right then?
It was right because I think money did not pass hands, and the matters were eventually laid before the legislature.
Yeah, but the president's explanation at the time was that he did it. So the president admitted that he should have gone through the National Assembly,
Yes.
unlike what you're saying.
There is what they call anticipatory approval.
So that was exactly the president. So the president accepted the error, unlike what you say now. The president accepted the error and said he did it in anticipation
Yes,
of the
anticipatory
approval
action, yes.
of the National Assembly.
Yes.
So does it go to say that there are specific cases like that where the president doesn't need to go to the National Assembly if there's an emergency window?
Doesn't need to go through the National Assembly first, because if the
Yes.
the National Assembly is on recess and something arises, he can take preemptive, protective action.
Without informing perhaps the leadership of the National Assembly?
No, sometimes they do. They do. They're always in the caucus, because it's almost always one party. Yes, they're always in the caucus.
Okay, so as we round off this conversation on treaties and agreements, let's look at the National Assembly's body language with regards to insisting on receiving these treaties, agreements, and protocols or details on certain loans that we receive in the country. Do you think that National Assembly over the years has stood its ground enough to get the respect of the executive to ensure that these documents come to them before, not after?
Like which document?
The documents that we talk about, for example, the SAMOA agreement, which you insist that National Assembly should have received before it was signed, but that hasn't happened.
I'm saying if it is a treaty, there may have been a treaty. This is like, to me, in my understanding, an agreement pursuant to an earlier document existing.
Which should go to the National Assembly.
Yes,
or
we
not?
should or should have gone to the.
So that's why I'm asking.
But even if at this time, before signing, perhaps at now, if it is a treaty, does not commit Nigeria.
Until
that signing is like intention that we agree that we're going to deal, but the effect, the perfection is going to be when Mr. President transmits it to the National Assembly to deal. And
7 whole months.
Yes.
The minister said that this document was with the executive arm, Minister of Finance, Foreign Affairs, Budget and National Planning, if I recall correctly, for 7 months since November before it was eventually signed. That wasn't enough time to take it to the National Assembly?
I will not go into it.
But it's an anomaly, isn't it?
I will not go into it.
Why? I mean, you clearly say that the National Assembly, the president could sign, but it's not effective until the National Assembly rationalizes it. And now we hear that 7 whole months went by. National Assembly didn't get it. Till this moment, there are lawmakers don't have details of this, because I called a number of them. In fact, I also spoke.
They can only have details of it, of what is laid before them. And of course, as I chaired I told you I chaired the committee on ad hoc committee on treaties in the House of Representatives, concurrently as chairman of Rules of Business. And it was things like this that, because there were treaties that were signed, and it ought to have come to the legislature. Now, even if you have it and you've seen it, you cannot bring it to the floor, because it is only the head of government, it is only the president, who is the signatory and representative of the country, that can bring it to you. So we could not introduce some of the treaties which we found. Are
you surprised that till this moment it's not come up in the National Assembly?
There is nothing the National Assembly can do unless it is laid before them.
I mean, they have not raised concerns. We were hoping to have seen statements.
No matter how much concern you raise, we've had this experience before.
Yeah.
We raised these concerns. We moved motions.
The concerns were raised.
Yes, we moved motions. We listed the treaties. I went to the Minister of Justice. They gave me the register of treaties. They certified to me the treaties, the Federal Minister of Justice. And I annexed it to the motion and moved that the executive should transmit these treaties to the National Assembly. I moved it, even in the Senate. But it was not done till today. So the present National Assembly cannot do anything about it if it had been like the convention. And I'm urging the National Assembly to take this matter to court is not fighting the executive to take it to court, because it will be helping Nigeria to determine whether all these treaties from 2002 till today, which is 22 years, which Nigeria has been signing without it being ratified by the National Assembly. Some binding states, which those states are not a party to it, because those states, treaties of a certain character, has to also pass through to the state houses of assembly and be approved by them before it can be finally passed by the National Assembly. They should take this matter for interpretation, either to the Supreme Court in its original jurisdiction. Because I believe firmly that the Federal Ministry of Justice is wrong, that the executive is wrong, that from 2002 till today, most treaties, which ought to, in fact, most of them were coming, at a point they stopped. They stopped sending, they stopped sending treaties. So they should, and the National Assembly now has committees on treaties, that is standing committees, not in my time when it was ad hoc, just to address, and it was ad hoc because we had concerns, and it was to address, but it hasn't been addressed. So the National Assembly or the Attorney General of the Federation, just like they have done in the case of, in certain cases, like the local government, should go to court to interpret whether treaties ought to be laid before the National Assembly before they can become a law. And if it is not, what is the legal status of the treaties, conventions, and protocols which Nigeria has entered into, even the ones that grant loan, from which they take loan? Because if it is not lawful, then it is at the risk of countries or institutions which has granted Nigeria money.
All right, Senator, let's move on to other pressing matters as well. One of them has to do with security, and it's the bill to ban open grazing, which scaled second reading in the Senate sometime last month. Has generated quite some reactions. On the floor of the Senate, it generated a heated debate, but eventually passed. Now, a lot of people are looking at it from the perspective of existing state bills. About 11 southern states already have the bill to have laws to ban open grazing. And people want to know how effective that has been before it's replicated at the national level. What's your take on this stance by the National Assembly, considering the Land Use Act?
Well, the Land Use Act has already provided that every local government shall provide grazing areas, grazing reserves. The Land Use Act has provided that every local government shall provide grazing reserves in its land management system in the local government. So, and the Constitution has provided that the Land Use Act, the National Securities Act, and the NYSC Act are part of the Constitution and integrated into the Constitution and deemed part of the Constitution. So every provision of NYSC Act, National Security Agencies Act, and the Land Use Act is deemed to be part of the Constitution. Is deemed to be part, is just to reduce the volume. When you add it, the Constitution is like this. When you add the 3, the Constitution will be like this. So they are part of the Constitution. Now, being part of the Constitution, it means that the Constitution has already provided that there shall be grazing reserves in every local government, and the states are also made to make grazing reserves. The Land Use Act also provides that lands in the states are to be vested in the governors of that state and the government of that state. So it is only the government of that state, it is only the governor of Benue State, Rivers State, Cross River State, Akwa Ibom State, my state, that can make law on the use of land, including grazing reserves, including grazing or no grazing. And again, it is also unconstitutional for any person, because the Constitution has provided the right to own property. Property includes cow, cattle, goats. Property includes yam, potatoes, vegetable, rice. That's property. Now, if I have a right to own a property, yam, potatoes, and farm produce, and you have a right to own your own cow, it is an infringement of my own right for you to carry your own cow to come in and eat my own potatoes or yam or vegetable or rice. So it is an infringement of right, and it is unconstitutional. Therefore, what do the governors do? The governors now have a right to make a law, even if it is surplusage, because for me it is surplusage, that no open grazing, that you cannot take your cow and graze openly in the land of another person.
As a former lawmaker, distinguished, I'm curious. There are constitutional provisions and then the Land Use Act that vest power in the control of land in the governors. Can a bill, which is not the constitutional amendment,
that's where I'm going. The National Assembly ordinarily, and I repeat ordinarily, has no right to make laws on the use or application of land in the states of the Federation except the Federal Capital Territory. Because the National Assembly is the legislative house of the Federal Capital Territory. But when you are faced with exigency and it has proceeded beyond land use to national security, it has progressed beyond land use to national security, it has progressed beyond land use to food security, it has progressed beyond land use to ethnic question, it has progressed beyond land use to what some persons say it is their own culture and their own way of life. And we don't have food. What is food? Cow, goat, sheep is part of food. Yam, potatoes, rice is part of food. If this other food comes to eat this other food, who suffers? It is Nigeria. What are we asked to do? We're asked to import food. Are the country we're importing food or practicing the same primitive thing that we are talking about? It is the right and culture. When that happens, the National Assembly has a right then to intervene and interfere by way of lawmaking. Anybody who feels aggrieved can now go to the court to set it aside.
But that's the intent of the bill.
Sorry?
That's the intent of the bill as canvassed in the National Assembly.
What is the intent?
You've just talked about
national security.
National security.
And food security.
Absolutely.
That's what I'm saying, that what ordinarily, and I repeated ordinarily twice, that it not thought to be a matter within the legislative jurisdiction of the National Assembly. But it has left the question of land use to land security, to food security. And so when it is no more a question of land, then the legislature can intervene because it has progressed beyond land to national security, to food security, to survival of Nigeria, to inter-ethnic and inter-religious and unity of Nigeria.
Well, let's look at the intent of this bill, which is to cure the crisis between farmers
and herders.
Mm-hmm. And also look at the 11 states that already have that law in place and see whether or not it's effective before we question whether or not there's a constitutional amendment process that should be carried out to ensure this, because you already say the National Assembly has no right to enact such a law.
Now, I in another forum where I made a presentation on this, I had said that, and I still say that, since it's a question of amendment of the Constitution, since it's a question of amendment of or dealing with the Land Use Act, they are not amending. They are simply taking steps to make laws pursuant to. If they want to amend and add that no cow should enter the rice farm, even if it is going to do as simplistic as that is as an example, I think they can go ahead and do it by way of.
But this is an establishment bill, though.
It's not an amendment. It's a commission.
Yes.
It's establish a body that will. Yes, you can, because if the laws, the Land Use Act was made in 1978. If from 1978 till now, which is over 40 years, which is over 40 years, and we are still having this situation, then something still...
So you think the land use actually be amended instead?
I don't think, I'm not saying, but they should do what they want to do. Because under the Buhari administration, this was faced. And it was agreed at the National Economic Council, chaired by the Vice President and by all the governors, that there should be the National Animal Transformation Plan. And that the question of the National Animal Transformation Plan is to enforce ranching. Ranch is not saying keep cow in one place. No. It is saying establish a farm complex where cow are raised this way, goats, sheep, ram are raised this way. Now you have water bodies. You have where you plant rice, where you plant yam, you plant potatoes, you plant cassava. All these are food. You take the manure from the cow and fertilize the rice farm, the cassava farm. And when you harvest maize from the maize farm, you give the leaves of maize to the cow to eat, and you take the dung from cow to fertilize the farm for maize. That is an integrated situation where all of them can live together, fertilize and eat one another.
Who provides the land for both of them?
No, it is the state government. It is the state government.
But there are private individuals farming.
Private individuals that also
how do we marry that with private individuals?
You can start doing it. This is one of the things I suggested to the Federal Ministry of Agriculture, that because I worked as advisor on Niger Delta Affairs, we had a plan, and we worked on getting the lands of the river basin authorities to work on emergency agricultural programs. And part of the emergency was to apply the land of the river basin authorities as models for the National Animal Transformation Plan, which was to be the ranch, turn the entire land of this to be a ranch, where you keep to be a farm settlement, where you have cow, you have the different kind of animal, you have where water here, you have school there, you have a hospital there, so that the person who works on the crops will be entitled to, his children will be in school, he has access to medical care, all within that, and I still suggest that to the present government.
Okay.
So the National Animal Transformation Plan was the improvement of the rural grazing areas, as it were. That was chaired by Professor Yemi Osinbajo, and all the governors were members, and they all agreed. And that was why when Katsina State was given a loan of about 6 or 8 billion naira, Katsina State. And I'm happy with the governor of Katsina State and the governor of some of the northern states who have come out to openly say that ranching is the way to go, and that this integrated farm settlement is the way to go. So the National Assembly is right, and they should go ahead with the
ban on open grazing.
Yeah, but the ban on open grazing is not just ban on open grazing, it's to set up a commission, a body that will monitor, that will solve some of these problems. And
but you say the National Assembly cannot legislate.
I say it doesn't ordinarily have. I've used the word. But it has, what the problem they face now is beyond land use. It has gone to national security, food security, and so you apply the doctrine of necessity to go beyond it, to go beyond the limit of your constitutional provisions. This is what we call in law. When in the court, when we have problem that is not expressly defined and situated within the jurisdiction of that court, and we now say inherent jurisdiction of the court.
Right. So this
is inherent jurisdiction, inherent legislative powers of the National Assembly. They can go ahead.
Well, we're speaking of amendments. Let's go to the NDLEA Amendment Act now and look at this proposed death penalty. It's been received with mixed feelings because for some, especially the National Human Rights Commission, Amnesty International as well, they believe that the world is moving away from the death penalty sentence. mostly because there are some persons who could be guilty for a bit, who would be seen as guilty, but over time will be proven innocent. So the world is moving away from the death penalty, but here we are pushing for death penalty for drug smugglers and peddlers. What do you think about this?
I wouldn't think so much about it. I want to say that drug is so bad. We've established National Drug Law Enforcement Agency. We established National Food and NAFDAC, National Agency for Food and Drug Administration. We've created several punishments. It doesn't go well. What have the successful countries in the world done that have successfully fought drug? And has it deterred? If whatever has deterred those countries and made it a deterrent, Nigeria should apply. Nigeria should apply.
So you think the capital punishment is the way to go?
I wouldn't say yes, I wouldn't say no.
Well, here's
but
why.
If it is what will stop the peddling of drugs, I'm sure what I know is that some of the people who push drugs don't even take it. They do it for economic reasons.
But here's why it's a concern for a lot of people coming from Nigeria. Nigeria on several occasions has had to canvass for the freedom of its citizens who were on death row for alleged drug smuggling.
But sometimes it is not because they have been proven guilty.
That's why I said alleged.
Sometimes it is the process of trial. Sometimes there is denial. Sometimes there are extraneous facts which may not have been made available. Sometimes it's a question of identity. That is when Nigeria intervenes. But well, a citizen of Nigeria, like the citizen of the United States or United Kingdom, in whatever, even on the death row, is still a citizen of that country and is entitled to diplomatic coverage or protection.
But should we be concerned about how we're perceived by the international community?
Well, the international community perceived us one way or the other. They perceived us and the economy is collapsing. The international community recommended several measures for us to take, and it has killed and collapsed our naira. It has brought much hardship. But international communities recommended several, including the World Bank, including the other Bretton Woods institutions. All their recommendations are things that collapse third world countries and give advantage to their sponsors.
Senator Enang, the Western countries where we get a lot of our support are not practicing.
They are not practicing those things.
The capital punishment. So if, you know,
they have abolished.
They are abolishing. Some have abolished, some are abolishing. You know, the concerns for many is trying to eliminate the capital punishment based on human rights.
I will not say
and
yes.
Nigeria has had cases of human rights violation.
I will not say yes or no.
Many fear.
But Nigeria is in a crossroad now. So whatever it is that will deter further complication of the problems of Nigeria, we should do.
Very well.
So that it could be a deterrent.
All right, then, so let's go into the re-election of President Bola Tinubu as ECOWAS chairman and what it means for Nigeria. Congratulations, by the way, to the president.
Congratulations to the president.
But we would have to be selfish about
Tinubu.
it. If the president is ECOWAS chairman, there must be benefits for Nigeria. So let's look at it. What does it mean for Nigeria going forward? He's been there for a year, so perhaps we might want to tie.
Well, I think this is a one-way occasion.
So we might look at what we benefited from his time.
This is first. His Excellency, Mr. President, as President of Nigeria and Chairman of ECOWAS concurrently, has shown character and consistency and consistence with democracy. And so when he sees any step or anything of any member state that is anti-democratic, he stands against it, as he stood against it. Consequences, yes, there are, but it's being managed. So, and this has been one of the things, in my opinion, which has given the other member countries who ought to have been taken over the term to say, Mr. President of Nigeria, continue so that you can do. And I'm sure you can also see that some of the neighbors of Nigeria, Niger, Mali, Burkina Faso, are now under military rule. And all this happened when he served in his first term as chairman of ECOWAS.
I think specifically Burkina Faso and Niger.
Yes, I beg your pardon. So these are countries...
But sorry to cut you in, we're almost out of time. Concerns around how he handled those situations have been raised, especially with Niger, with which we used to share very good economic relationship and security relationship.
There must be consequence of every action. And when that consequence arises, in diplomacy, you now put it on the table, weigh it all, and then know how you address each one of them. And the president of the new president of this other country has been appointed as a special envoy to relate with these other three countries. I believe that they'll be able to succeed. Although these other countries have conformed what they call Confederation of the Sahel states, we don't have to be discouraged about it. Nigeria has so much to benefit with a good relationship with Niger Republic. First, we share the same water, the River Niger, with Niger. If Niger successfully dams the River Niger, in their country, the amount of water, the quantum of water coming down to Nigeria may not be enough to turn the turbine in Kainji, and we will start having water problem. This is why we have the United Nations Convention on the Law of the Sea, that is the UNCLOS, where there is international convention on damming, and that there must be agreement, you know. And this is why we also had an agreement consequent upon the dam in Nigeria, in Kainji, to provide light power to Niger. So these are the complex diplomatic
concerns, right?
Concerns.
But
that's
you know,
the reason which we must manage.
And the security concerns are also important because this could affect the counter-terrorism activities in the Lake Chad, couldn't it?
It will.
Because Niger is one of the countries that has given Nigeria the most support in Africa with regards to fighting Boko Haram insurgency, Islamic State,
I think that is being addressed, and I get close to...
Are you confident that the president, in his capacity as ECOWAS chairman, will be able to solve this issue?
He has shown capacity to solve it. And it is the way he has managed these institutions and this problem that it hasn't escalated. And we should also, in managing and in relating with these countries, trying to bring them back, the ECOWAS chairman, or trying to relate with them, the ECOWAS chairman should also work and ensure that we don't have another enemy in our backyard, creating another power block to create a security stand in such countries that can endanger the security of Nigeria. The world of international security is become very complex. The West, Russia, North Korea, and the non-aligned. So these are matters that we have to consider very seriously in ECOWAS actions. And let me also urge Mr. President that as chairman of ECOWAS for a second consecutive term, that there is the protocol of 2016 signed by all the countries of ECOWAS, including President Buhari, in December 2016, where it was agreed that all countries in ECOWAS should send persons elected by universal suffrage in accordance with the electoral law of the country directly to ECOWAS. And that it was also, by that process, it was also agreed that countries will no more have dual representation, dual mandate of the members of the National Assembly. And as at 2005-2006, when ECOWAS Parliament was established, it was as an interim measure agreed in the protocol, in the establishing instrument, that the high state contracting parties should send members of their national legislature, elected members of their national legislature, to ECOWAS Parliament. But in 2016, They now said, after 10 years, no more. You should send only persons elected directly from by the government by the persons of those countries. So perhaps they may decide to mandate INEC or anybody that they want to, that the country wants to, any institution that they want to vest, to conduct election, to get Nigeria into electoral constituencies. Nigeria has 35 seats. And I had said it earlier, the part of the provision in the amended protocol is that 30% should be women. And so he should also ensure that that is complied with to send Nigerians to that this thing. May his tenure will be very successful. And thank you, Nigerians, for electing President Tinubu. And West Africa and Africa has so much confidence in him. And we shall help him to deliver. And
beneficial to the country. I'd like to thank you very much, Senator Enang, for your time on Political Paradigm.
Thanks for inviting.
You're always welcome. Senator Enang is a lawyer, former lawmaker, and former senior special assistant to President Muhammadu Buhari on National Assembly matters. Thank you very much for your time as well. Remember to catch this episode and others by simply searching for Political Paradigm on YouTube or go to channelstv.com. I'm Terry Ikumi. Goodbye.